phone. Yeah. Um, it's 2:41. I haven't gotten any phone calls today. So I thought we'd spend a few hours together looking at the Latin in these various state responses to the motions to dismiss. Yes. Now, this concept of the state defense counsel request that the state prove the defendant received actual notice of the petitioner's request for a permanent order in Cloud County Superior Court had sufficient basis to justify the imposition of the permanent order. Um, as I had noted, to be able to be prosecuted for a crime, I would have had to be in Sequim, Washington on December 31st of 2015. Yeah, and I wasn't. Now it's nice that the public defender's office and the defense counsel keeps arguing back and forth about proving myself as the defendant having actual notice of the petitioner's request. Yeah. Then there's the court themselves justifying the imposition of the permanent order. Now, as noted above, these are not required elements of the charged crime. Yeah. But what would be an element of the crime charged is that you would have to be in that city. Yes. And you'd have to prove that the individual that is being charged with the crime was in the actual city that the crime took place. Yeah. Now, I've seen this multiple times where the public defender and the prosecuting attorney, yes, they kind of miss the whole point of the charges of cyber stalking and the violation of domestic violence no contact order. Again, my defense attorney on November 1st of 2017. The defense filed a petition to have Mr. Budnick evaluated for competency pursuant to RCW 1077. It wasn't the prosecuting attorney. Obviously, the prosecuting attorney for the state did think that I was competent to stand trial. It was my own public defender that thought, well, we need to have a 1077. Now, in a report dated May 14th of 2018, an evaluator for Western State Hospital, Phyllis, found that I was not competent to stand trial, but advised the competency restoration efforts are recommended. Again, the issue is the two-count criminal complaint. I have to find the actual evidence that I was in Port Angeles, Washington on June 16th of 2017. I emailed that evidence to approximately 2,000 email addresses. Yes, it was a video of my actual location and the actual time that I was making the video on June 16th of 2017. And then there was the email that I had sent as I loaded it into the YouTube that afternoon. Yes. And then there's the actual documented evidence of the emails that were sent. Yes. And then if you were to look at the email addresses, the actual day and time that they received the email that had the actual time that I made the video and the actual time that I uploaded the video. Now again, Phyllis said I'm not competent. And these competency restoration efforts for Wednesday the 4th at 2 p.m. are going to restore me to the competency of realizing that when I say I wasn't in Brennan, yes, how can you restore somebody to competency when they emailed 2,000 email addresses on June 16th of 2017? Yes. Now it sounds crazy, okay? And then there's the issue of cyber stalking on or about June 16th of 2017. Let's say that we went through those 2,000 emails. I made a folder that I had actually titled June 16th, 2017. Sent it in probably 20 to 30,000 emails. But nobody actually reads the evidence. Now, to allow the involuntary administration of antipsychotic medication during Mr. Budnick, my restoration period, Now, in the intervening time, the defense filed a motion to dismiss count two. Why they didn't file a motion to dismiss count one? Violation of domestic violence no contact order. Mhm. Now, I noticed that my public defender, mm, mm, the order itself is not really the issue. Yeah. No one mentioned that I wasn't in Brennan, and the actual emails that I was sending was not cyber stalking. Now, this supra, yes, I think it's one of these Latin words. Yes, it is. As I understand it, Jack Range was able to pass the bar because of his apprenticeship at some sort of law firm. Yeah. Could you get me who it was that was educating Jack Range before he got his employment at the public defender's office? Now, to require me to have a 1077? Yes. Mm-hmm. Now, Brett Roberts, okay, deputy prosecuting attorney in the above captioned matter, familiar with the file. Bruce Hannafy said the same thing. An email sent by Mr. Budnick on Friday, June 16th of 2017 to not just numerous recipients, approximately 2,000 email addresses. I would say somewhere between 600 to 800 recipients, including Heidi Budnick's workplace. As I understand it, my wife actually works in the Brington School District. Yes. There was no one at the actual workplace of Heidi Budnick that would have received an email from me because I never emailed the Brennan or Quilcene school districts. Demanding, as in there are forgeries on an actual court order. Yes. There was no due process to myself. Right. There is no signature of the petitioner. Yes. And there are fraudulent statements on the actual order itself. Yeah. I was demanding that you enforce my civil rights. Now, among the many attachments associated with Mr. Budnick's June 16, 2017 demand, yes, to have the protection order dropped is a screenshot of the protection order itself. Yeah. Now, Mr. Brett Roberts, I never emailed numerous, hundreds upon hundreds of email recipients. I did not include any of the people at Heidi Budnick's workplace. Now, I declare under the penalty of perjury, all right, that under the laws of the state of Washington, that the foregoing is true and correct. To the best of your knowledge, why don't you give me the email addresses, yes, of the individuals employed people at Heidi Budnick's workplace, yeah, that received emails from me because I never emailed anyone at that workplace. Yeah. Now, I'm thinking you can go to prison for this, okay? Now, argument, okay. The court should deny the defendant's motion to dismiss. Although the matter is currently stayed pending resolution of the competency question, the state will address the defense motion because delay is unnecessary. As in, we should not delay the prosecuting of a person where we have the evidence they did not commit the crime. Yeah. We absolutely have to go forward right now.